Lep pozdrav vsem skupaj na drugem delu Zimske šole. Danes imamo dve predavanja pa delavnico. V prvem delu imamo gostovanje predavalce iz Izraela, Marija Varaki. It's a great honor to welcome Maria Varaki from Hebrew University in Jerusalem. And she will talk about right to fair trial international criminal law procedure. One also has to know that today is Maria's birthday.
Okay, and his birthday as well.
V prvem delu bomo imeli njeno predavanje, v drugem delu pa potem sledi delavnica z mano pa z Dejanom Valetičem. Tako da bomo kar začeli. Maria, the floor is yours.
Okay, thank you very much. Okay, thank you very much. Vala, am I right? Yes. I may come from Hebrew University, Jerusalem, but I'm Greek. Okay, so just to clarify that, it's always good. It's a pleasure for me being here. It's my first time in Slovenia. Thank you very much, Yoni, Matej, and Dan for organizing, for inviting me and organizing this trip. And I'm very happy to celebrate my birthday here. So I would like to say just a bit of words about me and introduce you. Don't be afraid, I'm a lawyer, but it's okay. We're still human beings, lawyers. And I'm going to talk to you about the right to fair trial in the national criminal law proceedings. The last years, and this is how I know Yerney, I have been an international criminal lawyer. I worked a little bit at the Office of the Prosecutor of the International Criminal Court. And I'm not going to deliver a quite heavy lecture because this is definitely not me. But I would like to give you the main, to map the ground regarding fair trial, rights, and international criminal law proceedings. And in that endeavor, I would like your help, actually. So basically what I'm planning to do is to have an interaction with you, ask you questions, very basic questions, and then we can come up with, we can do the lecture together. So, when you hear the word fair trial, the words, what does it come to your mind? I know that all of you take or already took or you're taking now some law courses. What does it come into your mind? If I speak too fast, please tell me. If I speak too, if I'm, you know, if you cannot hear, please tell me to speak up, especially from the last row. When you hear these two words, fair trial or right to fair trial, what does it come to your mind?
Right to defense.
Okay, that's a good point. What else? Don't be confused with the international arena. Think in domestic, within the domestic context. The right to fair trial.
Confrontations of all parties on court.
Now I would ask you to speak up, I'm sorry.
Yes, the confrontations of all parties on the court.
Okay, you mean like that both parties before, can you please elaborate on that?
I'm thinking more about the right to say your statement.
Okay, to defend yourself.
Yes.
Okay, to present yourself.
Yes.
Okay. By the way, in the material that it was sent to you, and maybe some of you had a look, maybe you didn't have time, it's fine. I would suggest you, when you have time, to start with the two chapters which come from the manual of the Office of the High Commissioner for Human Rights regarding administration of justice. And this manual was designed, it was a training process for lawyers, for prosecutors, and for judges, because, you know, we may be in the field, but also we lawyers, we don't know everything. So it's very important because there it really maps the ground, it gives all the international material, and would be of great help to start from that. So in the material I sent, there are these two chapters, and then there are 3 articles, which are more specialized articles focusing on the right on issues regarding fair trial rights and international criminal law procedure. Okay. So what I'm going to do for the rest hour and a half, basically, I should have you have to tell me, you know. It's first of all we will discuss about the fair trial, the right to fair trial, and your understanding about that. and then we'll move into international criminal law proceedings. But before we move there, I will explain to you the basic courts, a little bit about that, and we will finish with a critique, because nothing is black or white in this arena. So, okay, fair trial, you say right to defense, right? What else? If you were a defendant before a court, okay, if you were arrested, what would be your first concern? What would you like to have first?
Lawyer.
Lawyer. So you need legal representation. Okay. What else would you like? How would you like the investigator or the interrogator or the judge to be before you?
The judge appointed by court.
Okay.
Impartial judge.
Impartial judge. What else should the judge be? Impartial. As you say, independent, appointed by court. We have to think that the right to fair trial, basically, it takes in in all the procedures. So we have the pre-trial stage, we have the trial stage, and up to the conviction, basically. So first of all, you know, you can be arrested, you have to be brought before an investigator, depending on the system where you are, whether it's a civil law system or a common law system, where you have specific rights. And then during the trial stage, again, this right, you know, is interpreted into other rights. Okay, so we talked about this, that you have to be brought before an independent, impartial judge, and you have the right to defense. What about you? If someone accuses you of having committed a crime, what about? What do you have? What is your weapon against that? Until you are judged and convicted. Okay, that's also that you cannot be basically charged with a crime that was not already formed when you committed it. But what do you say? Am I guilty?
I'm innocent.
Okay, you're innocent. Perfect. How is that called in law, in legal terms? That you are innocent. You claim you're innocent. Hello. Okay, think there are two words about this day. It's something that you have, you carry your status as a defendant until you are tried and gradually convicted. It has to do with innocence. It's called presumption of innocence. Very, 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 very important right. Okay. So, okay, this is the legal knowledge we have. If we go to the international level, do you know, any one of you, have you ever had the international instruments, treaties, basically, that prescribe the right to fair trial in human rights? Or have anyone done human rights law here? Have you done a course on human rights law? Okay, perfect. So when it comes to your mind, the right to fair trial, and someone says, where can we find that in an international treaty? Where can you find that? Okay, all of you, yes. Sorry, one of you, and then you can...
European Conventions of Human Rights.
Okay, this is a regional treaty, because we are in Europe and we are part of the Council of Europe. This is a European Convention. But what about at the international, not European level? What is the treaty, the convention, the covenant that prescribes the right to fair trial? Any thought? Sorry?
Constitutional.
This is at the domestic level, constitutional. Let's say we have, we have three levels, okay? We have the international level, we have the regional level, and then we have the domestic level, which is what domestically the law prescribes for the right to fair trial. But international arena, there are some international treaties that prescribe that. Okay. The UN system, maybe that helps you a little bit within the UN system. Okay. Does anyone remember the name of this treaty that prescribes the right to fair trial? When it comes to the UN, when I tell you UN, what are the treaties or declarations that are very, very important within your mind? What do you think about the UN, apart from being in New York or in Geneva? we have the UN Declaration, but then specifically when it comes to civil and political rights, and this is where the right to fair trial is very much analyzed, is what we call the International Covenant of Civil and Political Rights, and the acronym is ICCPR, okay? This is the main international instrument regarding the right to fair trial, and there you have Article 14 of the International Covenant on Civil and Political Rights, which basically clarifies and steps all the things you told me before. And I can read you have that in your material. Article 14 of the ICCPR says that in the determination of any criminal charges against him or her, or of his rights and obligations, everyone shall be entitled to a fair and public hearing by a competent, independent, and impartial tribunal established by law. Okay, so this is the first thing that you mentioned as well. In paragraph 2, Article 14 says, everyone charged with a criminal offense shall have the right to be presumed innocent until proved guilty according to law. So this was a presumption of innocence that you mentioned as well. And then we have also another reference that you, in the back row, you say that no one shall be liable to be tried or punished again for an offense. Okay, that's a different one, for which he has already been finally convicted. Okay, do you know maybe in Latin terms how do we call that?
I knew it, but...
You knew it, okay, you knew the first Latin term. Okay, it's not. Can I ask you something? Let's say that I arrest you, okay? And you are in prison. When should I bring you before a judge? How long can I keep you? Can I keep you forever?
No.
No? Okay. I'm not going to give you dates now, but I can tell you that also the right to fair trial means that you have to be presented before a judge, not within a promptly time, not with an undue delay. Okay, this is very, very important. Okay, as you said, you know, all of you, we have the international level, then we have the regional level at the European Convention on Human Rights. I think there it's Article 6, the right to fair trial on the European Convention on Human Rights, which is very much relevant to you, Slovenian Greeks, because we are under the umbrella, okay? But there are other regions which also have regional instruments. So we have the Inter-American Convention on Human Rights, we have the African Charter on Humans and People's Rights, we even have the Arab Charter on Human Rights. So the right to fair trial with very slight variations, you know, is considered one of the core rights, human rights, especially civil and political rights. It's because it totally touches upon this principle of human dignity, that no one can be arrested and tried without basic human rights guarantees, okay? So the right to fair trial is very, 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 very important. I can tell you that the Human Rights Committee is the organ that supervises the application of the Covenant of Civil and Political Rights by the state parties. So, for example, Slovenia submits the report before the Human Rights Committee and say, we ratified, okay, we're a member of we have ratified the ICCPR, and this is how we apply. So the Human Rights Committee basically checks how Slovenia has implemented domestically all the provisions of the ICCPR and the right to fair trial. What they do also is they interpret the right to fair trial. So something that I didn't put in your material, but I think would be very, very helpful, is to provide you also with what we call general comment. So the Human Rights Committee, which are 18 expert members, mostly academics, okay, they interpret all the articles of the International Covenant on Civil and Political Rights, and they say, what does it mean, for example, that you have to be brought before a competent, independent, and impartial tribunal? And they give their own interpretation. In our case, regarding Article 14, we have general comment number 13. It's one of the oldest and first general comments by the Human Rights Committee, which indicates exactly the importance and the significance of the right to fair trial. Before I can proceed, did I convince you that this right is important? Would you give me another reason why this right is so important? Just think the historical context, the political context, what's going on the last 10 years. Don't take it into, don't see this right only isolated, but put it in the broader context. Guantanamo, very, very good. Well, very good. The war, the so-called war on terror, you know, that started after 2001. So, human rights provisions are not only, they do not apply in a vacuum, okay? I don't want to make it more complicated, but I can tell you that there are other fields of international law that apply and interact with human rights law. One of these is what we call humanitarian law, or law of wars. It sounds a little bit contradictory or oxymoron to talk about law of wars, but this is the point. We have to regulate. War is conducted in any case, okay? So we need to regulate. So Guantanamo, the right to fair trial. It is and not only Guantanamo. Like last week, we had some new reports regarding the so-called black holes of renditions. Does anything? Some flights coming between Afghanistan via Europe, all countries of Europe going to Cuba. So the right to fair trial was very, very, very much important. Why? Why is it so important to go back to basic things? Can I ask, okay, let me rephrase, I put it differently, the question. Do you think it's an absolute right? Are there circumstances where we can have an exception to the right to fair trial? Like what happened in Guantanamo, for example?
Well, they don't have the right to fair trial. It's not fulfilled.
Yes, just the way you think, because as I say, the way I put it in that the right to fair trial is very simple. As I said, the right to fair trial has various aspects, okay? So it starts from the beginning of your arrest and goes all the way towards the conviction or acquittal or whatever. So you have different things. But it's very, very true to go back to that, because the right to fair trial was one of the very first fundamental rights, as I say. And for many decades, all lawyers, we thought that it's clear-cut, that there was no way that there will be a discussion, that there will be exceptions, and either it was the law on the war on terror or something else, that we could make exceptions about that, until 10 years ago. And I can tell you that there was a huge, huge, huge discussion about the right to fair trial, and to what extent should be some limitations on the right to fair trial. And there are limitations, but there are only these limitations which are prescribed by law, okay, for specific occasions, either for public order or something else. So it's very, very important to make it clear, basically, that the right to fair trial is really, really one of the most important rights, because it affects not only our dignity, but what we can only lose, liberty. And losing liberty is the most important thing, okay? Having said that, okay, we had the war on law. There is this new field of international law that has been developed dramatically, I would say, the last 20 years. And this is what we call international criminal law, international criminal court. Does it ring any bell to you when, if I tell you about international criminal courts, what comes to your mind? From the newspapers, or from what you have studied or you have heard? Okay, let's say about crimes in international criminal. Sorry?
We have globalization and
Okay.
we have also criminal all over.
Mm-hmm. So you have crimes basically that take place all over the world. Okay, we call them transnational crimes. Can you think of one of these crimes?
Drugs.
Sorry?
Drugs.
Okay, drug trafficking. Yes, that's one of them. But
Genocide.
Yes. Okay. Okay, we go to the G word, the genocide thing. Okay, of course. We have different crimes, but when it comes to international criminal law, in the sense of hardcore international criminal law, what Gerne was doing or what I was doing in the past, we talk about very, very, very specific crimes. So you say the crime of crimes, as it is called, genocide. Can you think other crimes, very, very, at the same seriousness, gravity with genocide? So we have genocide. You know where we had lately genocide?
I don't know how to say it.
Okay, maybe someone can help me.
Human trafficking.
Oh, yes.
Human trafficking.
Yes,
okay.
sorry.
Okay. Human trafficking. Yes, it's a form of crime. It's what we call transnational crimes, but it's not in the core. It's not. It's not the crimes that I'm going to talk to you about now, and I will clarify one. Okay. We have human trafficking. We have drug trafficking. We have piracy. Yes. Also the last years, okay? But this is not what we are talking about. Let's go back to genocide. It's not a very pleasant subject, but let's go back to that. What else? Okay, someone can commit genocide, but if it's not genocide, it could be something else. Remember, I mean, in this region, in our region, basically, what happened 20 years ago? Okay, there was a war. There was a civil war. Okay, crimes were committed during this civil war. How do we call these crimes? War crimes. War crimes. So we have genocide, we have war crimes. What else can we have? Imagine, think a little bit. I'm sure you have heard. Only to read the daily newspapers, you know, you will see what's going on there. Okay, I don't want to torture you more. Okay, that's a crime as well. Okay, but I don't commit an international crime. We have crimes against humanity as well. Okay. So I will give you briefly a little bit the background regarding the development of international criminal law, the one that I'm going to focus, okay, and how I'm going to link it with the right to fair trial. Okay, so the right to fair trial, it was the first component, and now we're going slowly towards international criminal law. Okay, Nuremberg, does that ring anything? Does that ring any bell? World War II. What happened after World War II? What happened to the Nazi leaders who were arrested by the Allies? Was there a trial? Did they execute them?
They hang them.
Yes, but before or after the trial? Actually, you know, the joke...
First of all, they had a trial.
Yeah, but the joke was basically that they wanted really to execute them. They just wanted to execute them without the trial, but then they said, no, 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 no. And was it Churchill who wanted to execute them? I think it was Churchill and Stalin, they wanted them to be executed, and then it was Roosevelt from the United States coming and saying, no, we cannot do what they did, we cannot be at the same level. We have to apply the rule of law, we have to apply standards of justice, okay? Okay, there is lots of critique about Nuremberg, but I'm not going there, whether it was Victor Justice, who they, etc. But we started with Nuremberg, okay, in 1945, but this is very, very important. And then for a couple of decades, international criminal law was forgotten. Not because nothing happened, not because humanity was so fantastic, you know, because humanity is not fantastic, but we had the Cold War, okay? So we had these two major blocks, and there was no impossibility of agreement to create an international criminal court. An international criminal court, which would be a permanent court with jurisdiction to try to investigate and prosecute 3 initially, became 4 now, major core crimes. And this is genocide, war crimes, crimes against humanity, and aggression. I will explain to you. So then the 90s take place. What happened in the 90s? Historically, 2 major conflicts. One in our region, the other one in Africa. Can you come up? Like, sorry? Genocide in Rwanda, exactly. 800,000 people were massacred within within 4 months. Okay, and former Yugoslavia. No, we have the civil war in former Yugoslavia. Slovenia was very lucky to be outside that, but we didn't have a court at that time. There was no permanent court. So what did they do? They established 2 ad hoc tribunals. One for Rwanda and the other one for former Yugoslavia. So one, it is based in Tanzania, in Arusha, and it's called ICTR, R for Rwanda, and the other one is based in The Hague, and it's called ICTY. Both tribunals are about to close, I mean, after 20 years almost of operation, okay, with many, I'm not going into the effectiveness of these tribunals, but they did operate for 20 years, okay? This tribunal had a very specific jurisdiction. In Rwanda, it was very clear that it was genocide and crimes against humanity, and crimes, of course, sorry, and then we have the ICTY, where we have this judgment on genocide against Srebrenica. Okay? So, we have these tribunals who operated with many, many, many lawyers coming from various jurisdictions. You have lawyers coming from Canada, and United States, and Australia, coming from common law jurisdictions. You have lawyers coming from civil law jurisdictions like continental Europe, and operating and try to coordinate, to work together and come up with a procedural law. And then in 1998 in Rome, the international community manages to sign and ratify to found the International Criminal Court. And this is what we call the Rome Statute and the International Criminal Court, which started operating since 2002. It is based in The Hague. It's a permanent international criminal court. It has jurisdiction over 100, I think now 30-something countries. Of course, you know, the critique against this tribunal is United States. Member state? No. Is it Russia? No. Is it China? No. Is it Israel? No. Okay, so what's the purpose of this court? Anyway, I don't know if you have heard about this. If you read on the newspapers where this court focuses. Do you know what are the cases before this court? Have you heard anything about that? Okay. No. All of the cases that there are before the court at this time come from Africa. So we have a situation. I'm not going to say situation case. So they investigate the Darfur. You have heard about Darfur, yes. Okay? Darfur, Congo. Congo is so big. Congo is like the whole Europe, basically, the Democratic Republic of Congo. Northern Uganda, Kenya. They had elections 4 years ago. They are going to have elections next month. There was lots of violence among different tribes in Kenya. Côte d'Ivoire. And then we have the referral regarding Libya as well, the famous referral by the Security Council. And what, Mali? What else do we have? Côte d'Ivoire, Mali? I think that's it.
Colombia.
Sorry?
Colombia.
Yeah, Colombia, but it is and it's not Colombia. Okay. So there is a major accusation regarding this court, you know, that focuses only on Africa. But having given you this general map, how and apart from this court, we had also other small courts. You know, we had what we call internationalized courts. We had one in Cambodia, because, you know, in Cambodia also, there was genocide taking place in Cambodia during the Pol Pot regime. But we had also a special court for Sierra Leone, due to the civil war in Sierra Leone and the famous diamonds, the Bloody Diamonds war. We had also a hybrid court in East Timor, and we had a hybrid court in Kosovo. And now, in Bosnia, we have in Sarajevo, we have the War Crimes Chamber, which is again a hybrid court, but it's going to be totally domestic. I don't know now if all the international stuff, I think, almost left now. And they try cases which are not so serious, if, okay, you can say, coming from the ICTY, or domestic cases of crimes, you know, that took place during the civil war within the Bosnian jurisdiction. Okay. So why the right to fair trial? What is important? Who has the right to fair trial under international criminal law proceedings? Should a genocidaire have the right to fair trial? Someone who killed you, raped your daughter in front of your eyes? Someone who massacred your family? Isn't he entitled to the right to fair trial? Yes? Yes? What does the rest say? Isn't that outrageous that this person, you know, who comes from this village in Congo, is in this perfect prison in The Hague, with internet and everything, and great food, and he has legal representation as well, you know, whereas the victims in Congo or in Darfur, every day they're exposed to the danger, to the risk of being executed, of being raped, of being, of all the other, of being tortured. Yes?
Yes, because he's innocent. Guilty.
Has presumption of innocence.
Yes.
What about if he has confessed? Well, don't we have a special regime? Isn't that those crimes so outrageous, like what happened with the law, with the war on terror, you know, that human rights laws should not apply to the same thing? Should we make some exceptions for these people? Death penalty?
Yes.
Well, I'm sorry. Well, in European Union we cannot do it. Let's say we'll be kicked out if we do that. But also, although death penalty is not prohibited per se by international law, these tribunals cannot have the death penalty because it is considered to be against international law. So no matter what, these people, if they are convicted, they will never get the death penalty. Whereas if they are tried in Congo or in other countries, most likely they will be executed. So, okay. So, right to fair trial. So what should these people have? The accused, the defendant.
Human dignity.
Human dignity. Okay. How is that translated? How is your mind that translated under the spectrum of the right to fair trial that we talked before? They have human dignity, as every human being. I agree with you, okay? What should they have? Like, based on the rights we talked. As we said, we have those rights at the domestic level, regional, international level. Okay, so we have a defendant before a court. What should be his rights, or her rights? Okay, I can tell you, just to clarify the thing, not to leave you in anxiety, if you have any anxiety, that basically the International Covenant on Civil and Political Rights, the one that I talked to you before, has been more entirely, I would say almost entirely included within the statute of all the international criminal tribunals, with some variations. So the International Criminal Tribunal for the former Yugoslavia, for Rwanda, they had special provisions of the right to fair trial for defendants. This is the way also for the International Criminal Court, okay? In their own statute, which is the constitutive document of the International Criminal Court, we have a variety, we have a series of articles which prescribe in the most authoritative way the right to fair trial of the defendant. So I can read you two of them. It's Article 66, which refers to presumption of innocence. So again, you know, the right to fair trial is interpreted into the presumption of innocence. And also Article 67, which is called rights of the accused, in a very clear way, rights of the accused. So there it says, for example, that in the determination of any charge, the accused shall be entitled to a public hearing. as we say, public hearing. He should be informed promptly and in detail of the nature, cause and content of the charge. So when someone is brought before the court, the first thing they do is present himself, they bring him before the judges and they say, is that your name? Do you understand? These are the charges you have been accused of, you know, with full and proper translation. He has to be, or she has to be tried without undue delay. He must have adequate time for the preparation of his defense, especially within the international criminal law context. Guys, it's very, very, very important, because these people are accused of the most heinous crimes. It's what we say, crimes that shock the consciousness of the international community, and I hate these words anyway, but this is how it is. You see, I'm self-contradictory myself. And very, very, very important, and I want you to pay attention to that. Also, it's what we call about equality of arms. Does that bring, like, within the right to fair trial, that both parties must have the same possibility to present properly, adequately, both their cases, not only the prosecution, but also the defense as well. And also the prosecutor has a specific obligation to disclose to the defense evidence which is actually exculpatory. You know what means exculpatory? It's evidence which is in favor of the defendant. So if the prosecution gathers evidence that there are some elements where they say this is in favor of the defendant, the prosecution has the right, the obligation to submit this evidence to the lawyers of the defendant, okay, for his proper. And I clarify that because now the third will be specific case studies how the right to fair trial has been applied or non-applied within the international criminal law proceedings. Okay. There is something also in the Rome Statute, and I focus on the Rome Statute because this is the permanent international criminal court. The other tribunals will close down sooner or later, okay? But this court is going to stay there, most likely. Okay, we don't take that. Most likely it's going to stay there. So there also it says that when the judges interpret the law, okay, before them, they have to take under consideration human rights law, international human rights law. What does that mean? That they have to think of the jurisprudence and the decisions by the other international treaty bodies, like the Human Rights Committee, for example, which interprets the International Covenant on Civil and Political Rights. So they do not apply only the statute, it's not only in isolation, of course this is the first source, but they apply public international law and human rights law. Do you have any questions, Far? Is there something that you miss or something you want to ask, or is that clear or interesting to you?
Very interesting.
Sorry?
It's very interesting.
Okay. So, international criminal law. So there is a whole now, I would say, discussion regarding the right to fair trial before those defendants. And I'm telling you that because it's very, very interesting also to see how human rights, non-governmental organizations change a little bit their attitude. Do you think of any big human rights NGO? Something that you have heard?
Amnesty International.
Amnesty International.
Human Rights Watch.
Human Rights Watch, perfect. These are the biggest, I would say, the Anglophone at least world, you know. We have others. These NGOs were founded in the 60s, basically, to defend the right to fair trial. That was why they were founded, okay? Because in the 60s, we had the military regimes in several countries, where we had the issue with Northern Ireland, where basically the right to fair trial was not respected. However, gradually, within the international criminal law context, because everybody is shocked by those crimes, okay, the right to fair trial has been under attack a little bit, and has been under attack also by human rights NGOs. Okay, I'm giving you a little, which is very, very interesting, because they contradict themselves. Initially, they were to protect the defendants, and now it says, well, it's the victims we need to protect. Because those years, you know, we have this, what we call this victimization, we must protect the victim. So the victim has been sacred. It's the victim and everybody else is bad. So the right to fair trial comes second when it comes to the victims. And in particular tribunals like the International Criminal Court, the victims also have a particular standing. Because usually in criminal domestic proceedings, what do you have? I'm the judge. Okay? So opposite to me, who do I have? The parties. Who are the parties? Defendant and? Exactly. That's it. Okay? Now, before the International Criminal Court, we have the judges. Okay? From one side, we have the defendant. From the other side, we have the prosecution. And not only, we have something else. Can you think what else could be next to the prosecutor? What would, let's say, whose interest would be more linked to the prosecutor's interest? Who would like the defendant? Who would like to bring evidence against the accused, against the defendant? Sorry? Public. But which public? The public which is mostly linked. What do you say? Jury. We don't have jury in the common law, in the domestic system.
Victims.
Victims, exactly. But this is something which was not, it was an innovation in the international level. So it's not only the prosecution, but you have also the victims. The victims are represented, and the victims have been granted so many rights, but so many rights actually, that, anyway, I wouldn't say that has created problems, but that almost at the same level of the prosecution. So the victims can examine witnesses, they can bring evidence, they have a very, very different standing. And that right has been interpreted, many judges and many scholars who are in favor of this, I would say, upgraded role of the victims in these international criminal proceedings is that actually these are the people who are affected, okay? But of course, if I ask you, can you think of problems with the victim representation before the court? What would be something that would be problematic? What doesn't fit in the image? What do you think would bring problems?
They're too personally.
Emotionally,
Yes,
you mean?
yes, involved.
Yeah, definitely they are. But who is a victim? Who is a victim? Who qualifies as a victim?
Someone who suffers against the offendant.
Okay. Well, I can tell you that when the Rome Statute was enacted, they didn't actually know very well who is a victim, who qualifies as a victim. It was very good. It was very good because we have the victims there. We were all good people. Okay? We want to protect the victims. We care about the victims. You know, these bloody perpetrators have to be tried. However, the logistics, not only legal logistics, but I would say practical logistics, because if you have 1,000 victims in Congo, okay, not all of the victims can be there. Actually, we didn't know who is a victim because in the international criminal trial we have several stages. Okay, we have the pre-trial stage, we have the trial stage. Who is the victim? Is it the community itself? Is it the individual victim? Are they the relatives of the victim? Who is the victim? Anyway, there was a huge controversy during the first years of the operation of the International Criminal Court because the judges, especially judges coming from a civil law tradition, like Slovenia, right? You have partie civil here, civil party, yeah. They just granted too many rights to the victims. They interpreted the statute in a very loose way. And then they raised a controversy regarding the right to fair trial of the defendant. Okay. And then they say, well, yes, but the statute says that everybody is equal by the law, before the law. So it's not only the defendant that should have rights, it's also the prosecution that should have rights, and also the victim, which is a very, I would say, controversial interpretation of the provision of their own statute. It's, how can I say, it's self-contradictory interpretation of the provisions of their own statute, because even if we take, I don't know how familiar you are with interpretation of legal documents, but even if we take a contextual, like a literal interpretation, there are provisions where it says the rights of the defense, of the defendant, very clearly. There is no way to say the rights of the victims or the rights of the prosecutor, rights of the accused, okay? So that was very problematic, but it became a kind of, how can I say, religion, that we have to protect the victims to the expense, to the detriment of the rights of the accused. Because the whole international criminal law project is based on these crimes are so heinous that there is no way that anyone, you know, can not justify those crimes, but not to take a very strong position against those who are accused of those crimes. But we have reached also the level of forgetting basic principles of criminal law, of human rights law, like presumption of innocence. Okay? During the first years of the ad hoc tribunals, I want to mention, to bring you some case studies, especially in Rwanda. In Rwanda, the situation was chaotic. Okay? We had 800,000 victims. 800,000 victims. And we have thousands of perpetrators. And the judicial system was not working. It had collapsed in Rwanda. And the International Criminal Court, the ad hoc tribunal for Rwanda, was actually, it was a huge challenge to deal with those perpetrators. So there were many mistakes there. There were mistakes, procedural mistakes. There were perpetrators arrested in one country, and then the court, there was no proper cooperation between the court and this country, so the perpetrator and accused could be imprisoned, detained for months, even for years. Okay? Finally, he was transferred to the court in Tanzania, and then there were cases where he was tried, he was convicted, but then he appealed and he said, I'm sorry, but I have been detained for, I don't know, for 3-4 years, you know, and he was released. Okay? We had that situation. He was released because his right to fair trial was blatantly violated. And that was a very, very, very big problem. Also within the former Yugoslavia, we had similar instances of people, I remember mostly of Haradinaj, now lately in Kosovo. There were issues where, you know, from one side, it was this goal of an international criminal tribunal. What do we want to achieve? Do we want to bring justice, to give justice to the victims? So no matter what, we have to do that? Or are we here also to protect the human rights of the defendant? How are we going to balance these two goals? Which was a big challenge for all the people who were involved in this project. And I can tell you that the last years, you know, there is this project, maybe you are involved as well, no? The International Criminal Procedure. Okay. They try to come with a unified, I would say, interpretation, idea of international criminal law procedure, where also they try to identify which is the right to fair trial, what are the limits, what are the dynamics. But I can tell you it's very different, the domestic context, like being accused of robbery, okay, than being accused of genocide. And there the issue is that actually how far can we go? There are many scholars who say that we must have exceptions in the national criminal law because the challenges we face are beyond our capability of domestic criminal law, so the right to fair trial should not be applied at the same level, okay? Should be applied in a different level. This is very, very controversial, I can tell you. I'm not going to tell you we have a solution here, but this is an ongoing discussion. And the more we have tribunals, the more the tribunals function, the more we face those problems daily. Having said that, the International Criminal Court rendered its first decision last March. The first case was a warlord from Congo, Mr. Lubanga. Maybe you have heard his name somewhere, okay? He was convicted for enlisting and conscripted child soldiers and sentenced to jail for 14 years. Okay? 14 years. Many human rights groups, and especially women groups, reacted. They say, are you joking? 14 years, you know, has already been detained for 6 years. So these 6 years will be reduced. It will be deduced from the 14 years. Anyway, they wanted to bring also charges for sexual crimes, but they were not brought at the end. It was a major trial. Major trial. It was the very first trial of the first permanent International Criminal Court. What happened? Can you guess? Have you read anything about this trial? This trial lasted for 3 years. Did you by any chance follow some? This person was the first defendant before the International Criminal Court. The judges twice, they had to order stay of proceedings. Do you understand what that means? They had to stop the trial. Because they said that the way the office of the prosecutor, the prosecution worked, behaved, they couldn't guarantee fair trial rights. Imagine the embarrassment and the shock of the first of the Permanent International Criminal Court to say, sorry, it's our first case, but twice we stopped, the judges ordered to stop the proceedings, and not only that, to release the accused. Like the violation of his according to the judges, again, the violation of his fair trial rights were so grave that he had to be immediately released, twice. The first time was because the prosecutor did not submit exculpatory evidence, the evidence in favor of the defendant, to his defense. Okay? That was a major blow to the court. The second time again, the prosecutor had a big problem with his prosecution witnesses because he used what we say in legal terms, intermediaries, to collect evidence, you know, on the ground. So the prosecutor did not want to reveal the name of those people who basically acted between the prosecution and the victims on the ground. But twice, the defense of Mr. Lubanka accused the prosecution of the International Criminal Court of what there is another term, is called abuse of power. Not syndrome, abuse of power concept, basically, that the prosecutor abused its power, abuse of process power, basically. That the prosecutor abused the process. Twice, I can tell you, they freaked out at the office of the prosecutor. Twice, the judges who came at the appeals level, they rescued the prosecutor. Mr. Lubanga was not released for a variety of reasons, for legal purposes, but also for symbolic purposes, because imagine the first trial before a very expensive court, a very, very expensive court, that you say, oh, we have this guy, you know, and then he is released. Imagine what would be for the image of the court and for the legitimacy of the court. So anyway, in March 2012, the trial chamber rendered its decision, but it was very striking, because apart from the conviction, okay, for the guy, they invested the judges a very important, significant part of the decision, scrutinizing the office of the prosecutor for its methods regarding the investigation and what they did and what they used, the witnesses and all the procedural tactics they used during the trial. Basically, giving them a lesson and say, you know, you cannot behave this way, because this time we rescued you, although we had a serious violation of fair trial rights of the defendant. But next time, be very, very, very careful. It was the first time, I'm telling you, I don't know if you have never, I was very much surprised, but that indicated also, you know, that these things should not happen again. So, we have all this critique now. Anyway, now this defendant was convicted. It will go into the appeals chamber, blah, blah, blah. But the damage to the reputation, to the credibility of the court, I can guarantee you was really, really, really big. Because I don't know what was more important, to convict him for a specific crime, or all the discussion was not about his conviction at the end, it was about how his right to fair trial was violated. And that was unacceptable. That was unacceptable, especially by a court which is supposed to preserve human rights law, which is supposed to upgrade the standard of human rights law in the international arena. Questions? Do you still believe that any defendant, for example, had less right to fair trial, less fair trial rights? It's fine. I mean, you don't have to. We are not going to judge anyone. It's just curious. We talk about death penalty, for example, you know, but I'm asking.
Sometimes you would certainly wish, but it doesn't work this way.
Yes.
And I think it's okay.
Sorry?
I think that is that's okay because it's all about the justice.
It's all about the justice.
Yes.
But justice for whom?
Justice in general.
Okay, I'm saying that because I'm telling you the discussion is open. You know, it's a major discussion about that, how you combine human rights provision with international criminal law. Because at the end, as a domestic lawyer, as a domestic criminal lawyer, okay, it's very, very important to preserve those rights, because as I said at the beginning, it goes into the very core of our human liberty. Our liberty, our physical liberty is limited. So the interpretation generally of criminal law, as we learned, all of us, I think the university has to be very narrow. Okay? We go for a very narrow, strict interpretation of criminal law. You cannot expand criminal law. Even if you want to convict someone, you know, the purpose is not to expand. What happened with the international criminal tribunals was exactly the opposite. And I'm not sure, I am very, very criminal, but to some extent I can understand why. Because they didn't know at the beginning how to deal with this challenge. As I say, they had too many victims, they had too many perpetrators, they had pressure by the public, by people, you know, bring us justice. And by justice they meant we want convictions, okay? We want conviction. So the first years, basically, they came up with a very flexible interpretation of law, whether it was into the crimes, whether it was into, but also into procedural law. So in many respects they say, okay, we can speed up a little bit the process. I remember a decision, I don't remember the name of the Special Court for Sierra Leone, where they say we can speed up the process because that will be fair, it will be fair for the victims. So it doesn't matter about the defendant, the focus is on the victims, okay? So that happened, but it was also because of pressure that they had to prove, you know, that they're very much pro-victims. However, after 20 years, and especially nowadays, these things have to be corrected. Because if the right to fair trial is eroded in the international arena, then what is the message those tribunals they send to the domestic level, okay? And I can tell you that, for example, if you compare, it's very interesting as well, the World Trials Chamber in Bosnia with the international, with the ICTY, they give much harder conviction, much more the stricter decisions than the ICTY. So all these tribunals, they are interrelated, and it's very, 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 very important for their own legitimacy, but also for the functionality of the whole system, you know, to be able to preserve the basic provisions of public international law and human rights law. So what's going on in the national criminal law, and I don't want to bother you more and to make it more complicating, is that we suffer from a crisis. We have an existential crisis. What are we? Are we criminal lawyers? Because if we are criminal lawyers, we have to interpret law very strictly. Or are we something else? You know? Are we those who are going to bring justice to the rest of the world at any expense? That we don't care about basic procedural guarantees, but we have to proceed with justice? What are we? And there is no answer on that. I can tell you what I believe. I'm very critical towards this expansive interpretation of international criminal law. I think we have lost, we forget what we are. I'm in favor of victims, of course, who is not in favor, but it's not a matter of being pro or against victims, basically. It's a matter of applying the law. So, having said that, if you have any, I don't know what time
You still have some more if you...
Yes, I can open the discussion. I'm trying to think something more interesting as a case study to say about the right to fair trial. I can tell you that there are many former judges who work for the tribunals who retired or who come out now and they just talk a lot about what happened and how this procedure should be better corrected. But it is very true, but all these people were under extreme pressure by the public to render justice at any expense. And that created many problems. Do you have any questions? Something you would like to share, to say? Between domestic law and international law. Yes, maybe?
Well, maybe one of the reasons why those international courts apply more extensive interpretation of the law is that they were created in the first place to prosecute the most responsible for the crimes. So International Criminal Court was created because there was a lack of international forum to prosecute those people. So if somebody is brought to the court, it's sometimes taken for granted that he or she will be convicted at the end. So at the end, I mean, prosecution, the court and judges, they have a really difficult task to give the rights of the defense of those people.
Yeah, it's very true. And especially, as you said, especially within the International Criminal Court, because we also have the victims in the room, in the courtroom. The victims are there. There is more pressure to the judges to be more pro-victim, victim-oriented than dealing with the defendant. But at the end, we lawyers or judges or prosecutors, we cannot forget that. And this is why there are all these agencies like the Office of the High Commissioner for Human Rights which run regular trainings. Because even if you're a prosecutor and a judge, it's very good to go back and remember what is the basic principle of your profession, how you should interpret the law. And the right to fair trial is very important. And it was taken for granted, as I say, all these decades. Until the last decade, we had all these new developments that challenged the actual application of the right to fair trial. But maybe maybe you would like to say something more about the right to fair trial. Yes. Yes.
I have something else.
Yes.
I think that international criminal law is only against countries that are weak. Why I say that? Because I don't think we will ever see a resident of the United States on that court, or someone from Russia, or someone from China. It's always the countries who are weak and can be dominated either with military or money. That's why I think it will never be like 100% true for everybody on this world.
But I see your point, and this is a very valid, and I'm telling you, it's one of the major critiques against the whole project of international criminal justice. They say it's a hegemonic project, basically, of some countries against other countries, and there are specific countries which are accepted, as you say, the United States, Russia, China, Israel. I can tell you that. It's almost impossible, because for the International Criminal Court, in order to have jurisdiction, You understand what? In order to have the jurisdiction, either a state has to become a member state to accede, to ratify their own statute, but we have also another possibility that the Security Council is going to refer a situation before the court regarding, like for example, Libya, okay? Or Sudan, Darfur. Sudan and Libya were not member states to the International Criminal Court. But the Security Council said that because of the conflict and what has been taking place there, you go before the court. But that would never happen, it's very true. It would never happen for the 5 permanent members. You know which are the 5 permanent members of the Security Council? The United Nations? France, yes.
USA, Russia.
USA, Russia, yes. Okay, so imagine, so no one, like Russia, for example, China, or United States are immediately excluded because they would never vote against themselves. Okay, the same takes place for Israel, for example, because every time there is a referral, there is an attempt anyway that Israel is under the jurisdiction of any international criminal proceedings, the United States say no, they veto. Okay. However, having said that, this is the first stage, okay? What you say, this is the first stage which has to do with jurisdiction. But let's say that a citizen of United States, because a citizen of United States in principle, he cannot come before the jurisdiction of the court. Because if he commits a crime on the territory of a state party, of a state which is a member state with their own statute, do I speak too fast? Then he is exposed to the jurisdiction of the court. For example, we have the case of Iraq, okay? Iraq was not the case. No, it's the other way around. That's not
The
Afghanistan.
American soldiers were not under jurisdiction for
Well,
yeah. We couldn't judge an American soldier everywhere in the world because America says that American soldiers are for American judicial system, no matter where they are.
it's true that the United States, the first years, of the International Criminal Court, they proceeded with these bilateral agreements between states which were member states, like Romania, to the International Criminal Court, saying that if we will never send that our soldiers are excluded, our citizens, not soldiers, are excluded from the jurisdiction. But anyway, having said that, I'm saying that, okay, if they are, in case they are exposed to the jurisdiction of the court, still the law has to apply equally, okay? So we are not dealing here with the issue of the jurisdiction. We are dealing with a very specific issue, which is the application of human rights law, the right to fair trial before the court. And there the judges will not say, oh, he's an American, or he's a Russian, or he's a Chinese. They are not supposed to say that, and I can guarantee you they are not going to say. The accusation that the International Criminal Court focuses on Africa is a different issue, I agree. But then the justification is that the major crimes take place in Africa. Okay? Those crimes take place mostly in the continent of Africa. Okay? You can say about other countries like Colombia or Afghanistan, for example, or Israel and the Palestinians. Okay? Which is more complicated. I don't want to go into that. But definitely I see your point on that. But this is everything in international law, isn't that? It's law and power at the end.
I think
it's law and power. We can be a little bit ironic and we can be cynical, and I can tell you I'm very cynical myself. But on the other hand, like that, it's power that governs international relations. But law plays a huge, for a variety of reasons, also plays a huge role in the governing of international relations. But I think there was someone else who wanted to say something.
I wanted to ask you, what are some of the limitations to fair trial that you mentioned? There are some.
Okay, that was, yes, because I touched upon that, but I didn't. For example, Article 14, which says, that Article 14 of the International Covenant on Civil and Political Rights, it talks about a fair and public hearing, okay? sometimes we're not supposed to, you cannot have a public hearing for a variety of reasons. Either for reasons of national security, or I can tell you for what we say public order, for example. Or let's say we have a sexual crime, okay? And there, for obvious reasons, you know, the judges may say that no, you're not supposed to. When there is an indication also of exploitation of the right to fair trial, there, you know, again the judges, they can put a limit on the fair of that, but mostly it is the case of national security, for public order, for reasons of morality, or as they say, or when the interest of the private lives of the parties so requires, and they say for sexual crimes, or when it's strictly necessary. I mean, the limitation have to be absolutely necessary, strictly necessary, in special circumstances, I'm reading also, which publicity would prejudice the interest of justice. But any judgment, at the end, any judgment has to be, for example, also if you have minors, okay? Yes. There are other issues. Yes?
No, you mentioned interest of justice, no?
Oh yeah, on board, yeah.
You wrote a lot about that. Maybe you could explain. I mean, when can one interfere upon right to fair trial in the case of interest justice?
That's very interesting. I wrote my PhD on that, and I should have say the answer like that, you know, and I don't have the answer like that because the PhD was different on that. This is a claim, we say, for interest of justice, for example. It's a passepartout, I would say. In many legal documents, domestically or internationally, we have that. For example, in the interest of justice, the defendant should have legal representation. I think the interest of justice would be if there is I'm thinking of that, where the right to fair trial could be limited. If, for example, there was a major destabilization effect of the proper application of the right to fair trial. The right to fair trial, for example, in Northern, you know, Belfast, like Northern Ireland, state of emergencies. I'm sorry, come on, state of emergencies. We have what we call state of emergencies, for example, when you have an aggravated form of demonstration, riots, not like simple separated incidents of violence, but when violence becomes a daily practice. Then, for example, and that's why when Amnesty International was founded in the 60s for this reason, because then the British said for the Northern Irish, they say, okay, we deal with the state of emergency, and we have to impose specific restrictions to core human rights provisions, okay? But the state of emergency in all these covenants is very, very narrowly and very thoroughly prescribed, which says it has to be absolutely necessary, it has to be proportionate to what you want to achieve. There is a test of strict proportionality, and it has to be prescribed by law. And it has to be very, very narrow. You cannot say, oh, we impose state of emergency and you have this absolute, how can I say, loose. I mean, you have states of emergencies in military regimes, in dictatorships, okay? But you can have a state, an exceptional state of emergency in a democratic state on an exceptional basis. In those circumstances, yes, the right to fair trial can be reduced. In international criminal law, I cannot think of right to fair trial.
Being restricted.
What about, if I may, I mean,
yes.
You mentioned a bit of if somebody is misusing or abusing the
power,
the procedure, right?
Yeah.
As in Karadzic's case, you know, he asked for a year or 2 years in order to be able to familiarize himself with the indictment and, you know, to prepare his defense. I mean, in order to, I mean, and of course he claimed in his favor in the right of fair trial,
yeah.
right? So you have enough time to prepare, but to grant him 2 years, obviously it is it falls away from this right.
Yeah. Thanks,
The right to fair trial.
Matej, for that, because the right or a possibility of self-representation is a major, because you're entitled to legal representation, but also you can have, and Milosevic started that, okay? And there was a procrastination, basically, I don't want this lawyer, I want this, I don't want that, I don't, for years, until Milosevic died. Okay. And with current, this is very true, it's the same. And maybe you can help me on that. It's something that I'm not sure, I know, but it's a major issue. Where are the limits, of where do we stop and we say, basta, that's it, and now you abuse the process. And there it depends very much on the judges themselves, on the interpretation of jurisprudence by other entities, I would say the Human Rights Committee, or jurisprudence, previous decisions of ad hoc tribunals, to what extent, when they will say that this is an abuse of your power and you have to stop. But to be frank, I think you have done a bit of that. Frankly, I'm not into that, but I know that it's a major issue because it's very much conflicting. This right to especially right to self-representation. When you say I want to represent myself, but I want that and that and that, and then you procrastinate, you delay the proceedings. I think there, the delay of the proceedings comes from what we call the right to justice as well. Because there we have a balance of rights. From one side you have the right to fair trial, but from the other side you have the right to render justice for the victims. So I think everything it's a balance of rights where this test of proportionality has to be applied. But it comes to common logic. I don't know if we have some legal standards. You cannot delay for 5 years. There are some legal procedural standards. But the interpretation is very much the common logic. But maybe Gerning would have to add something on that. No, but it was true that especially in ICTY, it was a problem. The self-representation, it became. They didn't know. The judges didn't know how to deal with it because they will be accused if you say, "Okay, stop it," then immediately they were accused of violating his rights. It's the other side of the coin, as we say.
We could maybe, because the right to a fair trial, it's a composition of a variety of sub-rights, as you rightly described it, right?
Yeah.
And inside of this number of rights, you could, specify or identify certain rights that are actually absolute, like presumption of innocence.
Yes, it is.
That's an absolute right. You cannot balance it. There can be no proportionality against it. And maybe then also this prohibition against double jeopardy.
Yes, definitely.
That too.
Yes.
Or maybe that civilians cannot be tried by the military tribunals.
Yes.
And all I'm quoting from basically from the Slovenian constitution, right? But otherwise, for the rest, you must balance because you have.
But I think now they can interpret it with it. For example, you are not supposed to be tried and you delay. So
Yes.
it can be the other way around. And this is something that happened, for example, as I said before, with the International Criminal Court, when they say equality before law for the prosecution as well. Okay. But there, when it's very, it depends on the interpretation you want to give. Are we going for a literal, are we go for a contextual, are we go for a teleological interpretation, or what is our purpose? If our purpose is to render justice, then you can do it. If the purpose is like, it's the challenges. It's like new challenges that come up, and the judges, the people, we lawyers, I think we are not ready to deal with challenges because of this exceptional context. There is no excuse any longer to say, oh, we have a sui generis situation. More and more we have jurisprudence, and it's on ad hoc basis at the end. But I think it comes with a bit of common logic. This interest of justice provision at the end refers to common logic. Okay, a delay could be for 5 days, okay. It could be for 1 month, okay. But could it be for 2 years, okay? And also jurisprudence as well. Any other question? Something you would like to say?
Nobody else?
Something which was not clear to you, or
Now here Maria here, tomorrow she'll be again in Saloniki.
Yeah, tomorrow I will be stuck on strike in Greece, you know. So. I hope I didn't discourage you from the national criminal. I'm sure you're all very pro-victims, you know. There is nothing again to be pro-victims. No, the point is that there is no good and bad victim and defendant. I'm saying, you know, that we are lawyers and we have to apply law, or those who want to deal with law. But of course, at the end, you know, all of us will follow a little bit our morality, you know, because law does not apply in a vacuum. That's what I wanted to say. And this is very obvious with the judges. When the judges, they have this discretion to interpret the law. You see some of them, they say, because we have the victims, we have to apply in favor of the victims. There are other judges who, and it comes also where you come from. There are human rights lawyers who become judges, but there are also criminal lawyers who become judges. The criminal lawyers, I would say, they're more careful regarding this expansive interpretation of the law. But definitely that shows that law is a toy. You know, sorry, we can play with that.
Don't teach them that, come on.
All right.
I don't believe in international criminal law. I say law is a toy. Okay. Just forget this lecture. Anyway, thank you very much.
Maria, thank you very much.
It's not for the lecture. And also for your name.
Poznate neke bistvene sestavine, kaj vsebuje pravica do poštenega sojenja. Zdaj prihajamo v neko drugo dimenzijo. Spravi vprašanje, ali ta pravica do poštenega sojenja velja tudi pred upravnimi organi. A mora tudi upravni organi spoštovati temeljne sestavine, tako tele, ki vlajajo tudi v sodnem postopku. V sodnem postopku se slišali, zakaj sta pravica poštenega sojenja velja. Imamo v bistvu dve enakovredni stranki, ki nam imela enaka orožja in se med seboj spopadata z argumenti. In potem sodišče odloči, kdo prevladal v spor. Kaj bo pred upravnimi organi? A je kakšna razlika? Če primerjamo upravne organe pa sodne organe. A je mogla pravica poštenega sojenja tudi veljati pred upravnimi organi, a tukaj sploh ne gre za sojenje? Ne gre za sojenje. Zakaj pa gre? Kako pa temu rečemo? Odločanje, ne? Upravni organi odločajo v postopku. To se pa res slabo vidi, ne? Macar. Kljub temu se lahko vprašamo, a pravica do poštenega sojenja velja pred upravnimi organi ali ne? Do pravičnega odločanja. Gremo zdaj na kratko čez te sestavine, pravice do poštenega sojenja, ki že dobro poznate. Kaj pravi Evropska konvencija v 6. členu, ko govori o poštenem sojenju? Kdo lahko sodi? Nek organ, ki je ustanovljen z zakonom. Ne moramo se mi zdaj sedeti in izmed nas izvoliti nekoga, ki v potem sodi. Čeprav marsikdo izmed nas se to želi. Mora biti nek organ, ki je ustanovljen zakon. A pravi sodišča so ustanovljena zakon. Imamo 22 pa 23 člen ustave, ki govorite o pravici sodnega varstva, v tem zakonu o sodiščih, pa posebne postopkovne zakone, zakon o kazenskem, zakon o pravnem postopku in tako naprej. Kaj upravni organi? A so pri nas upravni organi ustanovljeni zakoni, a imajo pooblastilo za odločanje, ki je vsebovano v samem zakonu? Kje vam to piše, v katerem zakonu? Kateri tisto bo, ja veste, kateri tisti temeljni zakon, kateri se mora ne ZUP, zakon o splošnem upravnem postopku. Sprav, to je prva ta kvotira, ki je sestavni del pravice do poštenega sojenja. Organ, ki je ustanovljen zakon. In tukaj zato lahko rečemo, da za ta del pravice do poštenega sojenja velja, da morajo tudi upravni organi poštevati. Potem imamo naslednji temelj. Tukaj se dobro zapomnite, ko potem bo vaša naloga izoblikovati, opredeliti dobre prakse upravnih organov glede vsakega sestavnega dela te pravice poštenega sojenja. Kaj pa neodvisno sodišče? To velja v slovenskem ustavnem redu, pa tudi drugje, da mora biti sodišča neodvisno. Vsaj teoretično, če ne v praksi ne. Tako? Tudi sami sodniki morajo biti neodvisni. Tako v teoriji, v praksi pa drugo vprašanje. Kaj pa upravni organi? Nek delavec, upravni delavec, ki je upravni noto in zaprosite za potni list, pa niste državljani Republike Slovenije, pa da vam zraven date kuverto. Javnost mora pravilno postopiti, prav, da vas mora prijaviti. Kaznivo dejanje poskusa podkupnije, ne tega sprejeti. Zato, ker naj bi veljalo, da bi upravni organi ne bili neodvisni tudi, a to drži, da upravni organi ne bili neodvisni. Kot sodniki. Potem imamo nepristransko sodišče. In tukaj bo vaša naloga tekom delavnice, da pač opredelite tiste dobre prakse, ki bodo zagotovile, ki zagotavljajo, da upravni delavci, oziroma upravni organi delujejo samostojno, neodvisno, oziroma nepristransko. Ali upravni organ mora tudi odločiti nepristransko?
Ja.
Kako?
Morajo ravnati po zakonu in predpisi.
Za podlagi ustave in zakona. So pa tukaj določene razlike med sodišči pa upravnimi organi. Ali lahko nadrejeni, naprimer nek načelnik upravne enote, odredi svojemu podrejenemu, da odloča v tem in tem spisu?
V teoriji ne bi.
So take delikatne teme, Lahko nek nadrejeni, ali ima nek nadrejeni organ na lokalni samoupravi pristojnost, da neki vedeževalki izvedi neko stanovanje. Ali lahko nek načelnica upravne enote vzame spis, dosje določenemu upravnemu delavcu, ker meni, da tisti delavec ne dela strokovno, pa bi morda do drug boljše rešil spis. Kaj pa na sodišču? Lahko predsednik sodišča vzame nek sodni spis nekemu sodniku, ker mu ne zaupa, da bo dobro rešil del. Ne more, ker tukaj je razlika, sodniki so sami po sebi neodvisni. Upravni delavci so pa nimajo take neodvisnosti, so podrejeni svojemu načelniku. Ok, kaj pa javnost? Marija zdaj veliko govorila o javnosti. Za pravico do poštenega sojenja velja, da mora biti praviloma sojenje javno. Izjemoma pa se lahko zapre glavna obravnava. Kaj pa pred upravnimi organi, kako običajno poteka postopek? Javnost ima pogled v nek spis. Nima, v večini primerov nima pogleda v nek spis. Razen kdaj? Če izkaže interes, če gre za zahtevo po zakonu informacije dostopa informacije javnega značaja. Če daj. Ko upravni organ razpiše obravnavo, javno obravnavo, to je pa zelo redko. V zelo redkih zadevah upravni organ razpiše javno obravnavo, predvsem na drugi stopnji to organ je razpiše. Tukaj spet nekaj razlika med sodišči pa upravnimi organi. Tukaj v vaša naloga pa že pišete tiste dobre prakse, ki bi jih morali upravni organi spoštovati. Pričem javnosti. Tukaj se lahko pomagate z različnimi zakoni. Potem bomo šli pa vsi skupaj čez. Še en kriterij pomemben, ne? Poštenost. Ima upravni organ nalogo, da zagotavlja, da je postopek pošten. Pa kako lahko javnost to nabira, da je postopek pošten? Da je pravilen zakonit. Poštenost pa ni pomembna, kako? Pravičnost. Vedno, ko govorimo o upravnem pravu ali pa o upravnem postopku, tukaj glavna značilnost upravnega prava je kaj? Neka nadrejenost državnega organa v razmerju do zasebnega subjekta. Državni javni organ je vedno nadrejen nekemu zasebnemu subjektu. In tukaj se potem postavlja vprašanje, kako zagotoviti potem neko varstvo pravic posameznika v upravnem postopku. Ker v sodnih postopkih imamo enakovrednost orožij, enako strank v postopku, obe stranki v postopku sta enakovredni v sodnem postopku. Pred upravnimi organi pa ne, je pa ena stranka nadrejena drugi. Kako se potem lahko sploh zagotavlja poštenost v postopku? Če ena stranka nadrejena drugi.
Vsi stranki v postopku, kakšne so njene pravice?
Pravna sredstva, sodno varstvo, potem ultima ratio, zadnje sredstvo. Kako? Načela, še kaj drugega? Nadzor. Sploh lahko govorimo o poštenosti v upravnem postopku. To bo tudi vaša naloga, da na to odgovorite. To je etični element. Tukaj imamo neki inkvizicijski postopek morda, bi to rekel, če bi vam pretiravali. Državni organ diskrecijsko odloča o naših pravicah, v večini primerov. Na podlagi ustave in zakona, to se vemo. Kako potem zagotovimo, da bo ta postopek res pošten, da se ne bo v ta postopek vmešali interesi trenutnega župana ali pa predsednika vlade?
Zdaj se ne sme, ker mi delamo po zakonu dejansko, ne po pravičnosti, ne razsojamo.
Se pravi, zakonito za pravičnost na ločenje.
Ne za te skupaj smo. Je za odločeno po zakonu.
Z možnostjo nadzora.
To drži, ne. Gre za odločanje po zakonu, vendar, a to pomeni, da morajo organi odločati pravično. Odločajo po zakonu, ali ne? En primer na tukaj v Mariboru, ne? Se veste, da že dolgo časa je tukaj ena izmed prioritet v Mariboru, da bi na tem bregu Drave pač zarasla neka nova umetnostna galerija. Predstavljate se, da vi ste upravni delavec, ki je dobil prošnjo za izdajo gradbenega pa lokacijskega dovoljenja v tem postopku. Hkrati pa veste, da v ozadju tega projekta so določeni interesi, določene skupine, ki želijo zgraditi to umetnostno galerijo. Morda res iz nekega kulturnega iz višjih kulturnih razlogov, morda pa v zadnjem so pa še drugi razlogi. Ne? Kako bi potem odločil v takšnem postopku pošteno? Da bi odobrili gradbeno dovoljenje pa lokacijsko dovoljenje?
Če je skladno z odlokom občinskim.
Če spolnjuje tista prošnja vse tiste zakonske pogoje. A bi se v samem postopku spraševala, je to pravično?
Ne.
A se upravni organ mora spraševati, a je pravično pošteno, da se tam zgradi galerija? Pa da se mesto tega ne zgradi nek dom za Rome tukaj. Dobro, to so vprašanja za vrš. Tukaj pa še zadnji element te pravice do poštenega sojenja je pa sojenje oziroma odločanje v nekem razumnem roku. Odločanje v nekem razumnem roku. Tukaj je zopet razlika med sodnimi in upravnimi organi. Pravica do nepotrebnega odlašanja pri sodišči nima nekih rokov, kdaj morajo sodišče odločiti. Čeprav morda bi bili roki primerni. Po drugi strani, kako? Po zakonu o splošnem upravnem postopku pa imajo upravni organi točno določene roke. Kdaj morajo odločiti v teh zadevah. Če gre za skrajšanje upravni postopek, kakšen je rok? Tako, 30 dni. Običajno je ta rok 60 dni. Rok postaja, ne? Kaj pa, če se rok ne spoštuje? Pa molk, ne? Organa predvsem tožbe na drugo stopno. Če še na drugi stopni je rok zamojen, ne? Imate potem tožbo v upravnem sporu, ne? Dobro, no? Zdaj vaša naloga je, da se razdelite v skupine po 5. Po 5, oziroma, če nekje nekdo želi 6 ali 4, ne? In prva vaša prva naloga je, da malo podiskutirate pa da opredelite dobre prakse, kakšne je bile dobre prakse delovanja upravnih organov, da zagotovijo svojo nepristranost. Kaj bi mogel upravni organ storiti, da zagotovi svojo nepristranost? In tukaj ne pozabiti, da ta nepristranost ni samo notranja, v razmerju samega organa, temveč velikokrat se tukaj govori tudi o nekem zunanjem videzu nepristranosti. Da morajo sodišča upravni organi ustvariti nek zunanji videz neodvisnosti pa nepristranosti. Spravi, to je prvo vprašanje. Kako naj upravni organi delujejo nepristrano? Pa kjer je bila tiste najboljše dobre prakse? Pa jaz bi tako predlagal, da morda, ko nas je toliko veliko te predavalnici, da morda polovica od vas gre v manjšo predavalnico, ki bo tam več prostora. Morda tisti zadnji del predavalnice. Pa bo tam z vami, bo Dejan, z vami. Madro bo še 15 minut za to prvo.